Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. I'm back, everybody. 3 years of this, and I've come to realize there's just something about summer and precedential immigration decisions. The courts like to publish a lot of immigration in the summer. Who knew? The things you learn. Got a bunch this week, and they are glorious. And how about Liz Word taking the reins last week, huh? I appreciate them immensely. Even the wicked need rest. And for all of those curious, yes, Liz is a Swiftie to an unhealthy degree, and has let her loyalties infect my podcast. You are the problem, Liz. It's you. I suspect Eddie might also be a Swiftie, but I have no proof. Here are the cases, sans Taylor Swift. Our first case in this wonderful week of cases is Ullah v. Garland, published by the 4th Circuit on July 6, 2023. We're starting off with 4 asylum-type cases. And how did this guy lose before the immigration judge and the BIA? The 4th Circuit begins as follows. Quote, "The United States war in Afghanistan required regional allies willing to aid the effort. One such ally was Shakir Ullah, a Pakistani businessman who sold supplies to coalition forces. This invoked the wrath of the Pakistani Taliban, which demanded exorbitant payments from Mr. Ullah under threat of death. Mr. Ullah repeatedly refused, and the Taliban attempted to carry out its threat, promising to hunt him until it succeeded. After losing his business, home, and nearly his life, Mr. Ullah fled to the United States, seeking asylum." End quote. A Ben Winograd case. Well, Mr. Ullah was from Pakistan and not Afghanistan. Whatever, let's back up. Mr. Ullah grew up in the former federally administered tribal areas known as FATA, a quasi-colonial, largely rural area near the Afghanistan border. Quote, "The FATA region is unstable, described as a sanctuary for the Taliban, Al-Qaeda, and other fighters. Terrorist activity is prevalent." End quote. Mr. Ullah, though, made it through, got a university degree, and became a successful businessman in FATA. U.S. Armed Forces were some of Mr. Ullah's clients and his father's before his. The family sold cars, tires, and oil, until the Taliban destroyed his family's oil tanker. The Pakistani Taliban, that is, and they got wise to it all, labeled Mr. Ullah a traitor, and demanded money as tribute. Mr. Ullah refused. Having done some Pakistani Taliban work myself on a case, they're quite dangerous. They're the ones who shot Malala Yousafzai for going to school, and they're the ones that pretty much went to war with the Pakistani government for a few years in the early 2000s. And of course they support their brethren in Afghanistan. True to form with Mr. Ullah, they threatened to murder him unless he paid about $1 million. He refused, and he couldn't do it anyway. And after all, that would be material support of terrorism under completely nonsensical BIA precedent, right? Mr. Ullah reported the threats to local tribal leaders, but the threats continued. Eventually, Taliban members ambushed Mr. Ullah at his office and beat him. It all continued until the Taliban gave him an ultimatum to pay or die. Local leaders wouldn't help, so Mr. Ullah hid in his home. He couldn't escape to the U.S. because he was denied a student visa. And there really aren't that many other ways for an asylum seeker from the Fatah to reasonably get to the United States. Mr. Ullah hid in his home and went to his business only periodically. Quote, during this time, 2 persons on motorcycles fired guns into a car carrying Mr. Ullah, his brother, and his security guard. His brother and guard were severely hurt but survived. Mr. Ullah suffered minor injuries. The Taliban called Mr. Ullah afterwards, warning that he wouldn't survive its next attack. End quote. Mr. Ullah closed shop and fled to the United Arab Emirates. He stayed there a month and returned to Peshawar, the largest city near the Fatah if I'm not mistaken. Universally recognized as a dangerous city. The Taliban found him and delivered a letter warning that, quote, only death can spare Shakar Ullah, end quote. Probably hits a bit better in the original Pashtun or Urdu. He fled to Islamabad where he stayed for 3 or 4 weeks before his friend kicked him out because the Taliban kept calling. Quote, I cannot put my life in danger, end quote, explained the friend. Denied a visa twice, Mr. Ullah figured out a way to get smuggled to the United States, it seems, where he was then detained and put in immigration prison by ICE. The IJ and the BIA found Mr. Ullah credible, and that he had suffered past persecution due to his imputed pro-American political opinion. That would have meant he gets asylum unless DHS can show that conditions have fundamentally and materially changed in Pakistan, or that Mr. Ullah reasonably can relocate in Pakistan and remain safe. DHS has this burden by a preponderance of the evidence. Met here, said the agency. 3 to 4 weeks in Islamabad will do that to you. Joking aside, personal story. Our firm once actually flew to Islamabad with oil to take depositions in a naturalization case. During that trip, the Trump administration moved the U.S. Embassy in Israel to Jerusalem. The Department of State deemed Islamabad so unsafe that oil and our attorneys weren't permitted to leave their hotel room in Islamabad during the entire trip, over 1 week. Would have given you that evidence, Ben, if only you had asked. Anyway, the Fourth Circuit disagreed with the IJ and the BIA on the reasonableness of relocation. Quote, our examination of the record reveals that Mr. Ullah's case has bite, end quote. Explained the Fourth Circuit, no reasonable adjudicator could listen to Mr. Ullah's story and review the evidence, which by the way shows that the Taliban is still active in the Fatah and looking for Mr. Ullah, and conclude that his 3 or 4 weeks in Islamabad satisfied DHS's burden. That the Taliban didn't contact Mr. Ullah during that time is of little significance to the court. Indeed, in another published case, the Fourth Circuit has held that 8 months of no contact by a persecutor will still not satisfy DHS's relocation burden. The focus of relocation, reasoned the Fourth Circuit, is, quote, for the rest of his or her life, end quote. Emphasis by the court. That is, to rebut for asylum, DHS must show that it is more likely than not that for the rest of an applicant's life they won't be persecuted once in a relocated area. So stated, that's a hell of a burden for DHS to meet, no? If so held to it. And of course, assuming past persecution is already shown as it was here. But, quote, a lack of contact standing alone doesn't rebut the presumption, end quote. The court also deemed it relevant that Mr. Ullah never left the house while in Islamabad, and he's not expected to live in hiding for the rest of his life. That's the Fourth Circuit and BIA precedent, and the Third and the Ninth and the 10th Circuit based on my recollection. Quote, the IJ also speculated that Mr. Ullah's 10 siblings who live in different areas could help him get situated. While this suggests an ability to relocate, it says nothing about whether Mr. Ullah would be safe in those different areas. In fact, the Taliban found Mr. Ullah at his brother's house in Peshawar, end quote. Mr. Ullah was getting threatened over the phone constantly, in multiple locations. DHS didn't meet its burden here. And, quote, the government didn't ask Mr. Ullah if he or his family had heard from his tormentors since then. The government can't now rely on a silent record to rebut the presumption that Mr. Ullah will be subject to future persecution, end quote. God, I love burdens. That country reports show that the Taliban is more prevalent in the Fatah doesn't show that they aren't in Islamabad. Believing the matter resolved, the Fourth Circuit, quote, remanded with instructions to grant his application, end quote, the gold standard. At risk of saying it too often on the podcast, congratulations to Ben Winograd for petitioner. Heck of a win. And that is Ullah v. Garland. Next is Chen v. Garland, published by the Fourth Circuit on July 6, 2023. Our cup overfloweth from the Fourth on July 6th. This case is mostly about corroboration, and it's a great win by another friend of the pod. Mr. Chen is from China and entered the United States on a student visa in 2009. I don't think it's hyperbole to say that many institutions in the U.S. would go bankrupt or have to charge their U.S. citizen students huge fees were it not for their robust foreign studies program, frequented most, it seems, by Chinese and Indian nationals on F-1 visas. Mr. Chen was one such national, but he never attended school, thereby violating his non-immigrant status. Nor did he apply for asylum until 2014, well after the one-year deadline. USCIS appears to have denied that application, landing Mr. Chen in removal proceedings. Mr. Chen claimed that he had been persecuted by the Chinese government for his Christian beliefs and practices in 2008, before he came to the U.S. as a student. He attended an illegal house church, it seems, which was broken up by police in July 2008. He was interrogated, forced to confess his crimes, and identify leaders. Then, when he refused, he was beaten violently by police, and police threatened to break his legs. He was imprisoned for 3 days, wherein police encouraged other inmates to harm Mr. Chen. He was released after paying a fine, signing a confession, and promising never to engage in illegal practices like attending a non-government-affiliated church again. A fairly common story. Doesn't make it fake. Could just as easily indicate that the Chinese government instructs its police to persecute members of underground house churches in this manner. Mr. Chen had to regularly report to police, who continued to abuse him mentally and threatened him, interrogating him to identify members. He fled China in 2009 with the help of friends. He recently learned that he had been accused of violating his agreement with police and committing new crimes. An affidavit from Mr. Chen's mother corroborated his story. An immigration judge deemed Mr. Chen's asylum application untimely, indeed by about 4 years. Although Mr. Chen argued that the police's continued searching for him constituted changed circumstances to excuse the one-year deadline, the IJ disagreed. The IJ then denied withholding of removal, deeming Mr. Chen's story insufficiently corroborated. No adverse credibility finding, though. The IJ denied Convention Against Torture protection for a, quote, similar reason, end quote. The BIA affirmed. The Fourth Circuit sent it back. It was confused and needed clarification. First, it didn't quite understand why the BIA believed Mr. Chen had failed to establish changed circumstances to overcome his one-year filing deadline for asylum. Under Fourth Circuit precedent, quote, an intensification of a pre-existing threat of persecution or new instances of persecution of the same kind suffered in the past may indeed amount to changed circumstances, end quote. The Fourth Circuit seems to think that the IJ and the BIA may have violated this rule here. If the BIA had held, as it might have, that because, quote, police already were searching for Mr. Chen when he left China, a continuation of such searches could never qualify as a change in circumstances, end quote, well, the BIA and or the IJ erred. So what'd you hold, BIA? Inquiring minds on the Fourth want to know. As to withholding of removal, that's going back too. That was a straight failure to corroborate holding, remember? But in the 2020 decision, Wambura v. Barr, the Fourth Circuit held that, quote, before requiring an applicant to provide evidence which corroborates otherwise credible testimony, an IJ must make a threshold determination that there is testimony that is otherwise credible, but still in need of corroboration, end quote. Everyone agrees that the IJ didn't make that threshold determination here. So the case was sent back to determine whether, in fact, the IJ's corroboration finding satisfied Fourth Circuit requirements. On remand, the Fourth Circuit also wants the BIA, and presumably the IJ, to address another issue, which may really be the governing through line here. A lack of corroboration can't be held against an asylum seeker unless an IJ finds that it was reasonable for the asylum seeker to obtain the corroborating evidence. Here, Mr. Chen repeatedly explained that he couldn't get affidavits from his fellow house church members and leaders in China because they themselves feared reprisals from the Chinese government. Was that a sufficient reason not to get the affidavits? Maybe. Maybe not. The IJ and the BIA never said one way or the other. Plus, explained the Fourth, neither the IJ nor the BIA ever assessed or even referred to the Department of State reports submitted by Mr. Chen, which contain information that the Fourth believes relevantly, quote, alarming, end quote. Continuing on that, quote, the failure of the agency to engage with this highly material evidence significantly undermines our ability to review its conclusion, end quote. Doubly relevant here, as the State Department reports could show both why Mr. Chen's fear of persecution is reasonable and why those fellow church members won't come forward with affidavits. Remands all around. And congratulations to friend of the podcast, Tamara Aljezik. This decision has come out the other way many times. Hats off to the litigator. And wouldn't you know it, here comes Ben Winograd again, who, according to Tamara, quote, helped moot me for Chen, and I helped moot him for Ullah, end quote. Look at these Fourth Circuit immigration attorneys helping out one another. What a nice bunch. With all this celebration, I've got a little cold water to pour. In the Fourth Circuit, based on this decision, it appears that an IJ may avoid that Wambura corroboration rule if the IJ simply holds that the, quote, testimony and documentation taken together did not meet the applicant's burden of proof, end quote. But that's not what the IJ did in this case, conceded oil. To be honest, I'm having difficulty understanding the difference between finding testimony credible and then implicating Wambura's threshold determination versus simply weighing credible testimony with other evidence and finding it all insufficient without implicating Wambura. But who am I? And Tamara Jezik certainly gets it, so there you go. Don't want to end on that weird note, so here's this, quote, several federal courts of appeals have had occasion to consider the decisive role that may be played in immigration proceedings by country condition reports detailing persecution of Christians in China, end quote. So wrap yourself in those several federal courts, if you have a similar case. And that is Chen v. Garland. Next up is Osorio-Morales v. Garland, published by the Seventh Circuit on July 5th, 2023. This case is about family-based asylum claims. Mr. Osorio-Morales is from Honduras. In 1996, one of his family members began dating a woman. But that woman was also dating another man, someone in the Hernandez family. A shootout ensued between the two men, and Mr. Osorio-Morales' family member was killed. In retaliation, Mr. Osorio-Morales' family killed a member of the Hernandez family. Mr. Osorio-Morales didn't do any of this, indeed he wasn't even born yet. Later that year, the Hernandez family set fire to the Osorio family home, killing Mr. Osorio-Morales' grandmother. His father hid under a car during an incident. Two uncles barely escaped. No convictions ever occurred for any of this in Honduras. Quote, so began a decades-long bloody feud between the Osorio and Hernandez families. Mr. Osorio-Morales was born under the shadow of this violence just 1 year later, end quote. Although Mr. Osorio-Morales was never harmed, he always lived in fear. Over 15 years, family members were killed or paralyzed, seemingly on both sides. One of Mr. Osorio-Morales' family members committed suicide as a result of the hostilities. Mr. Osorio-Morales couldn't take it anymore and he fled to the U.S. in 2014. Apprehended in 2015, he applied for asylum and related relief in immigration court. And in the least astonishing claim ever made on the podcast, Mr. Osorio-Morales asserted that he was due asylum on account of his membership in the particular social group comprised of his family. Although deemed credible, an immigration judge denied the claim. Despite a lifetime of fear, the IJ held that Mr. Osorio-Morales hadn't actually suffered past persecution because he was never harmed. That left Mr. Osorio-Morales with the full asylum and withholding of removal burden, which the IJ held he couldn't meet because, for example, he hadn't shown that the Honduran government was unable or unwilling to protect him, as asylum law requires. Not only that reason to the IJ, but Mr. Osorio-Morales had lived in Honduras without being murdered for years, and most of his family still lived there. The BIA affirmed. The Convention Against Torture Protection was denied too, but that wasn't challenged before the Seventh Circuit. The analysis here mostly comes down to the Honduran government's ability or willingness to protect. Because after all, quote, persecution under the INA does not encompass purely private actions. Rather, to receive protection under the statute, the persecution must be inflicted by the government or by private actors whom the government is unable or unwilling to control, end quote. While it's certainly a case-specific analysis, the Seventh Circuit has found that a foreign government satisfies this standard to protect if they're trying, but they're not doing so perfectly. And perhaps more importantly here, although the standard is found nowhere in the statute, the Seventh Circuit and other courts have, quote, found it reasonable, even in cases of extreme violence, to expect asylum seekers to have sought help from the authorities before concluding that their country is unable or unwilling to protect them, end quote. And it helps as well if the evidence shows, quote, systemic rather than individual failures, end quote, by a government to protect. Don't be fooled, quote, police apathy can indicate a government's unwillingness or inability to protect an applicant, end quote, as can a decision by local law enforcement not to prosecute conduct when it is reported. It's just rarely decisive in the Seventh Circuit, said the panel. High evidentiary burdens for asylum seekers fleeing death, no? These standards proved fatal here. For example, although no one was ever prosecuted for that fire, the government did investigate it a little, and in any event, the Osorio family never reported it. To the Seventh Circuit, that showed that the government was willing. That unable or unwilling standard has an or, though, not an and. An asylum seeker doesn't need to show that the government is unable and unwilling. It's unable or unwilling. So even if willing, was the Honduran government able to protect Mr. Osorio-Morales? The Seventh Circuit does not appear to have discussed this. Nevertheless, Mr. Osorio-Morales lost. The Seventh Circuit concludes as follows, quote, we do not intend to downplay the gravity of Mr. Osorio-Morales' situation. He has spent his entire life under the threat of a violent dispute that he neither started nor encouraged. But no matter how sympathetic his case, our law does not permit us to grant asylum where an IJ has reasonably found that a foreign government is willing and able to help the asylum seeker, end quote. No room here for Mr. Osorio-Morales per United States law. And that is Osorio-Morales v. Garland. One more before we take a quick break. Uriostegui-Teran v. Garland, published by the 8th Circuit on July 6, 2023. Mr. Uriostegui-Teran is a rancher from Mexico who fears returning. His uncles, he explained, were kidnapped twice for ransom. Police were notified the second time but were unable to do anything. People have also come to his home and demanded money at threat of kidnapping. And he has been chased by vans when leaving his home. Very scary stuff if you think about it. Mr. Uriostegui-Teran fired a gun at assailants one time and reported the incidents to police, even requesting a police escort. He was thereafter threatened with death and had extortion demanded of him through family members. Seems like it was a gang doing all of this, but the decision is not quite clear. He entered the United States seemingly without authorization, and seemingly through counsel asserted that he had been persecuted on account of no less than 12 particular social groups, hoping that at least one would stick. And hey, don't get me wrong, I do it too. And the BIA has essentially demanded it, with its precedent deeming a particular social group waived, if not asserted before the immigration judge. The IJ deemed all 12 not cognizable, and then held that in any event, the harm suffered and feared lacked the nexus to any of them. Those weren't the reasons, mere extortion, reasoned the agency. That common refrain. Cat denied too, the BIA affirmed. And the 8th Circuit dispensed with the appeal rather quickly. Quote, his first 6 proposed social groups, cattle ranchers, landowners, and business owners and their families, fail for lack of social distinction, end quote. No evidence, at least in this case to the court, that Mexican society views these groups as distinct. Quote, the BIA also did not err in rejecting proposed social groups 7 through 11. The Uriostegui-Teran, and Uriostegui-Jimenez families, and the families of gang kidnapping and gang extortion victims for lack of particularity, end quote. Yes, a nuclear family can be a particular social group, but the Eighth Circuit believed that these ones lacked clear boundaries, as they, quote, could include fathers, mothers, siblings, uncles, aunts, nieces, nephews, grandparents, cousins, and others, end quote. As to the 12th group, quote, deported Americanized Mexicans/Ponchos, end quote, it's also not socially distinct, reasoned the court. Quote, the record contains no evidence supporting his assertion that people deported from the United States to Mexico are recognized as a socially distinct group, end quote. Turning to Convention Against Torture Protection, government acquiescence or willful blindness is required when it's not the government that the applicant fears. Quote, a government does not acquiesce in the torture of its citizens merely because it is aware of torture but powerless to stop it. But it does cross the line into acquiescence when it shows willful blindness towards the torture of citizens by third parties, end quote. Here, though, the police didn't turn a blind eye when, for example, one of Mr. Uriostegui-Teran's uncles was killed. So too when he was chased by vans. They didn't turn a blind eye. So, Mr. Uriostegui-Teran lost his case. And that is Uriostegui-Teran v. Garland. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOURNEY30. Or click on the link in the show notes. This podcast is also sponsored by Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would otherwise not qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services families need. They offer affordable financing with no closing fee or down payments for those working with attorneys to move their case forward and get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651 and tell them who sent you. Thought I'd get through a little housekeeping from the 9th and 11th circuits before we got back to the precedential decisions. So in addition to all these cases this week, the 9th Circuit also narrowly avoided going en banc on the very complicated and very bad for non-citizens Mendoza-Linares v. Garland, from episode 131. That pesty monster of a case about credible fear review and so many things. Check out episode 131 for a refresher. Not happy about the refusal to reconsider the decision en banc, Judge Berzon, joined by 12 judges on the 9th Circuit, dissented from the denial of rehearing. It is far too wonky of a statutory textual fight to do the dissent justice here without first doing the whole majority again, and of course, the dissents didn't win the day. But at base, the dissent takes issue with what the majority essentially holds is that non-citizens deemed arriving aliens under immigration law have no constitutional rights, or that they have so little rights that they have evaporated into near-nothingness. Not so much the majority's fault, though, there. That Pandora's box of differentiating between the rights of humans on U.S. soil was opened in the modern era by Justice Alito and Thoracicum, way back on episode 9. But due to the vibrant dissent in this denial of rehearing en banc, it seems that even the majority opinion now recognizes that an as-applied constitutional challenge to the statute at issue remains to be fought in the future, should expedited removal proceedings and a no credible fear finding be instituted and made against a non-citizen who is not deemed an arriving alien. The statute permits this to happen, that is, expedited removal proceedings against individuals, for example, who have entered without inspection, rather than arriving aliens. And the Trump administration sought to expand that applicability to its outermost limits to encompass as many non-citizens as legally possible during its time in power. So anyway, Mendoza-Linares v. Garland from episode 131 remains good law, but there exists hope for an important, similar challenge in the future. So that's Mendoza-Linares from this week. While we're keeping up the House, the 11th Circuit slightly amended its awesome decision Ruiz v. U.S. Attorney General from episode 160. That big case about extreme cruelty in the Violence Against Women Act context. Not really sure what changed after a skim, but it doesn't seem overly important. The main good holdings from Ruiz appear to be good law. Just make sure you cite to this new, updated decision. And that is some housekeeping from the 9th and 11th Circuits. Alright, it's crimmigration time. Next up is United States v. Lungaho and Janus v. United States, both published by the 8th Circuit on July 6, 2023. Thought I'd do 2 crime of violence cases in the sentence enhancement context, both published by the 8th Circuit on the same day. Remember, U.S. citizens. Mr. Lungaho was, quote, angry after the death of George Floyd. The government claims that he and his friends channeled their anger into destroying as much police property as possible. In addition to slashing tires and breaking windows, they threw Molotov cocktails at 3 police cars, end quote. That resulted in 13 federal criminal charges. One of those is federal arson. And if arson is a crime of violence, then Mr. Lungaho's sentence is enhanced because he had a destructive device while he was doing it, the Molotov cocktails. But arson is not a crime of violence, explained the 8th Circuit, and in fact the district court before it. Only the U.S. government, arguing otherwise on interlocutory appeal, believes otherwise. But the U.S. government is wrong. Like in immigration, the relevant statute requires that to be a crime of violence. The arson statute must require the use, attempted use, or threatened use of physical force. As the Supreme Court held in Bourdain, crimes that can be committed recklessly don't meet this definition. That's what this case turned on. The federal arson statute uses the word maliciously. This term and the term malice that underlies it have been used for hundreds of years in jurisprudence and appear in a lot of federal statutes. Reviewing all that precedent, quote, malice is close to recklessness, except for one subtle difference. A reckless act involves consciously disregarding a substantial and unjustified risk, but unlike a malice one, the risk need not come anywhere close to a likelihood, end quote. Restated malice is slightly higher than reckless, but it's below knowledge, explained the 8th Circuit. That places the 8th directly in the middle of a post-Bourdain circuit split. If the mens rea is more than reckless, but less than knowledge, is it a crime of violence? It is not, explained the 8th Circuit, at least when that mens rea is maliciously. Although the circuits are really just getting their bearings here. Still gong-worthy. The 8th Circuit believed that all of this flowed from the Bourdain plurality, including Justice Thomas's concurrence. To satisfy the crime of violence, force required. Quote, what is required, in other words, is targeting. The conduct must be consciously directed at someone or something, end quote. Federal arson requires merely a willful disregard of a likelihood of harm. That is different from intending. as the Eighth Circuit believes necessary to satisfy Bourdain. Quote, although malice involves a higher level of risk than recklessness, the two share a common trait. Neither requires actors to consciously direct their acts towards a specific person or property. End quote. There's your standard, crimmigration gurus. Give it a rewind. Here's an example to make it more plain. Quote, a man plans to visit a national park and set off fireworks to celebrate the 4th of July. The only problem is that there is an extreme forest fire warning. Despite the high risk involved, he decides to go forward with his plan anyway, knowing that there is a good chance, say 60%, that he will burn down a nearby park ranger station. Sure enough, the fireworks spark a massive fire that consumes it. On these facts, no one would say that the man targeted the ranger station. End quote. Schmuck for sure, and someone who perhaps should be eaten by a bear. Also, a man who committed arson, but not a violent criminal. So that's a big deal, right? The Eighth Circuit has just essentially held that maliciously is materially identical to recklessly for crime of violence purposes. And thousands of crimes use the mens rea of maliciously, it seems. And not only will a reckless mens rea tank a crime of violence finding, but it'll make a CIMT finding difficult. In one podcaster's opinion, supported by certain BIA decisions. Not only that, of course, the Eighth Circuit has now weighed in on the issue left open in Bourdain. What mental state, in between reckless and knowing, will cut it for crime of violence purposes? The mental state of maliciously, and seemingly malice, will not. So, great win for non-citizens on crime of violence. A bit bad, though, for another aggravated felony statute at INA Section 11843E, which expressly is tied to the federal arson statute at issue in this case, along with some other federal statutes. If the Eighth Circuit had held that federal arson requires the attempted, threatened, or actual use of physical force, a lot of state arson-type crimes would have probably been excluded from the aggravated felony definition at Section 11843E. But whatever, that's an underutilized aggravated felony anyway, right? While we're with the Eighth Circuit, though, as I promised, again, the Eighth also published Janus v. United States. I use my inherent discretion and severely limited time to kind of only do non-immigration crime of violence cases when they push the law in a direction good for non-citizens. So briefly suffice it to say, the federal crime of second-degree murder is a crime of violence. It requires the mens rea of malice aforethought, and that is different from the malice that we just discussed in federal arson. Malice aforethought, according to the Eighth Circuit, requires that a, quote, defendant be blameworthy in mind before he can be found guilty, end quote. The Janus decision is also pretty bad for the crime of violence consequences of a statute that required a mens rea of extreme recklessness as well, whatever that mens rea means. Thinnest of lines, these mens rea cases. By the way, quote, Miss Janus shot and killed her husband when she found him cheating, end quote. And that is United States v. Lungaho and Janus v. United States. That brings us to Madrid-Mancia v. Attorney General of the United States, published by the Third Circuit on July 3rd, 2023. The Third Circuit has entered the fray on deficient NTA in absentia motions to reopen. And boy, howdy did they. Miss Madrid-Mancia is from Honduras, entered the United States without authorization, was detained, was released from detention, and was served with a deficient notice to appear. She provided ICE with the address that she'd be living at, but then she eventually moved, and she didn't update ICE. She tried to by appearing at an ICE office to do it, because that makes sense, right? But the ICE office told her that she couldn't update her address at the office. Looks like she never updated her address with ICE or the immigration court as the NTA told her to. Through the mail, I believe, is the proper way. 3 years later, the immigration court sent her a notice of hearing at that old address. She wasn't there, didn't receive the notice, didn't show up at the hearing, and was ordered removed in absentia in the dirty jurors in August of 2017. In her motion to reopen with the immigration court, Miss Madrid-Mancia said that she had a cousin at the old address who would check, and that she herself checked the old address often, but that she never got the hearing notice. She got the order for her to appear for deportation, though, in October 2019. She reported, and having learned of her issue at that time when she reported for her deportation, quote, promptly moved to reopen her proceeding and rescind her in absentia removal order for lack of proper notice, end quote. The IJ and the BIA denied. The Third Circuit said, you're the problem. It's you, DHS. Damn you, Liz. The Third Circuit spent some time going through the statute and history of all this, but regular pod listeners know a lot of it well. Beginning with the Pereira decision and then in Chavez, just what happens when DHS serves a non-citizen with a notice to appear that lacks the date, time, or location of their first hearing is quite muddy. INA Section 239A requires that NTAs have that information, but DHS hasn't been doing it in many of the thousands or tens of thousands of cases that it has begun since 1997. And actually, I learned something with this decision. It seems like the whole reason DHS was not complying with the statutory requirements for having all this information in the NTA began with a regulation from 1979 that permitted then former INS to fix its case-initiating documents later with a notice of hearing, because according to the agency, providing the date, time, and location of the first hearing in the case-initiating document was, quote, not possible, end quote. So it's Jimmy Carter's fault. Case closed. A lot of problems for DOJ there, though. First of all, back in '79, INS was both the immigration prosecutor and the adjudicator, so it was all one agency sending out all these notices. Now it's two, DOJ and DHS. More problematic for DOJ and now DHS is that Congress made that statutory requirement for case-initiating documents, now known as notices to appear, much stricter in IRIRA. That's when INA Section 239A and NTAs came into force. DOJ saw this problem coming in 1997, according to this decision, but didn't change course. And now, the Georgia peanut has come home to roost. DOJ's refusal to comply with the new IRIRA NTA rule was, quote, a convenience Congress did not write into the bills passed by both houses and presented to the President for approval, end quote. That's a heck of a background, right? More relevant here, what happens when a non-citizen fails to show up for their hearing after receiving a deficient NTA and is ordered removed in absentia? The text of the in absentia statute in our textualist world has proven a boon for non-citizens on this issue. Quote, any non-citizen who, after written notice required under paragraph 1 or 2 of section 239A has been provided to the non-citizen, does not attend a proceeding under this section, shall be ordered removed in absentia if the government establishes by clear, unequivocal, and convincing evidence that the written notice was so provided, end quote. But as that text makes clear, albeit not to the 11th Circuit, quote, the removal mandate, a non-citizen who misses a removal hearing must be ordered to leave the country, comes with a condition precedent. The non-citizen must have received the required notice before the hearing, end quote. And you don't receive the required notice in a deficient NTA. The text of the in absentia reopening statute is similarly clear to the court. An in absentia removal order, quote, may be rescinded at any time if the non-citizen demonstrates that the non-citizen did not receive notice in accordance with paragraph 1 or 2 of section 239A, end quote. And so from there, it's pretty straightforward to the Third Circuit. An NTA that doesn't comply with section 239A doesn't provide the notice in accordance with section 239A. So proceedings must be reopened and the in absentia removal order rescinded in such cases. Congratulations, Third Circuit practitioners. A notice of hearing, explained the court, only comes into play if the NTA first complies with INA Section 239A. All of that conflicts with at least the 11th Circuit and maybe the 6th Circuit, but it's in accordance with the 1st Circuit and 9th Circuits. I'll get to you, 5th Circuit, in a sec. Why can't a notice of hearing suffice? Asks the BIA as it ponders its own precedential decision on this issue, because matter of La Para is now zombie precedent, vacated on direct petition for review by the First Circuit. If you got through that run-on sentence, here's why. Because the statute that governs notices of hearing refers to a, quote, change or postponement in time or place of such proceeding, end quote. And you can't change a hearing that was never set in an NTA. EOIR might call those documents notices of hearing, but, quote, that is not what Congress said, and one needs no years of law school to see the difference between a notice of hearing and a notice of change in time or place of proceedings, end quote. Shots fired. Quote, notice in steps or stages may be efficient or convenient, end quote. But, quoting 360-year-old precedent, quote, the personal liberty of individuals cannot ever be abridged at the mere discretion of the executive without the explicit permission of the laws, end quote. Gonna need to go dust off my colonial-era wig. There's like 10 more pages of this, but that's really all there is, to me anyway. But also this, quote, no reasonable diner would expect to get seating for two by calling a restaurant to change a reservation he never made. Confusion, not a boarding pass, would follow a traveler's request to change a flight from business to first class when no seat of any kind had been purchased. Informing the dealership that you want to change your new convertible from metallic blue to classic silver only gets you a different color if you have already bought the car, end quote. All of this still almost surely doesn't apply to pre-arrira orders to show cause, though, as the BIA has also already held. Congratulations Alexandra N. Gunturyuk and Jill S. Westerberg for petitioner. Welcome to the party, Third Circuit. Continuing on before we go. Note: Miss Madrid-Mancia technically never updated her address with ICE or, of course, the Immigration Court. The Third Circuit clearly does not care. Indeed, to hold a failure to update address against Miss Madrid-Mancia, as other circuits would have, quote, finds not a bit of support in the text, end quote. Although I'm not going to lie, I'm not sure what the result of this case would have been had Miss Madrid-Mancia not provided a sufficient address in the first place, or not continued to check the cousin's mailbox at the old home. But the decision is quite strong on the text, so I'm bullish. The Third Circuit also does not care whether Miss Madrid-Mancia rebutted the presumption that her notice of hearing was properly delivered. And I see you, former BIA Chairman Paul Schmidt, along with that roundtable, with your amicus citation and footnote. Did I mention matter of Lepara is dead under all reasonable interpretations of administrative law because it has been vacated on direct petition for review by the First Circuit? The BIA's seminal decision on the issue, vacated by the First, is not even cited to in this 25-page, single-space, 12-footnote decision. And that is Madrid-Mancia, the Attorney General of the United States. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.